Brown. We went to all the honky-tonks. We really got around. She's 5'2" with eyes of blue and pretty eyes.
Hello, ladies and gentlemen. My name is Mark DiCarlo. Tonight, my guest is Judge Marisela Saldena. Thank you for coming on, Judge.
Absolutely.
Judge of which court?
Judge of the 148th District Court.
For many years now, right?
I am actually just completing my first term in the 148th District Court. I have served Nueces County as Judge of County Court Law 3 for 3 complete terms. That would be 12 years. So added up, Mark, 12 years plus 3 years, 15 years on the bench. Happy to say.
Happy to say. And of course you do, what kind of cases do you handle? You handle criminal law, you handle family law, you handle what other kind of law?
Well, the courts, all the courts of Nueces County are still courts of general jurisdiction. That means that we do the full gamut of cases. In county court, we addressed probate and estate administration, civil cases, concurrent jurisdiction with the district courts, and criminal, that being the minor cases, the misdemeanor cases. In district court, we, again being courts of general jurisdiction, address civil cases and criminal cases. And of course, unlike the county courts at law, we handle family cases.
So did you ever do a capital murder case in your court?
We have.
Capital murder case wherein it was going to be decided whether or not somebody was going to receive the death penalty?
That's correct.
In your court, have you ever had to state that somebody is sentenced to death?
I've had one capital murder case. Fortunately, we do not have very many of those in any jurisdiction in the state of Texas, but courts from time to time have to address a capital case. That ultimate decision of whether to prosecute it as a capital case rests, of course, with the Office of the District Attorney.
Yes, the district attorney makes a decision whether or not to submit to the jury. If the person is found guilty of capital murder, they don't necessarily have to seek the death penalty, correct?
Well, that's a declaration that's made at the outset. It's either, that's why I said the ultimate decision of whether that case is going to be prosecuted as a capital case rests with the Office of the District Attorney.
So in other words, what I'm basically insinuating is you do not decide whether or not someone just gets the death penalty if the person is found guilty of capital murder. You're not the one that decides that, correct?
That's correct. It's the jury's call.
The jury decides that based upon what?
There's a two-pronged test, and if the jury makes one hurdle, they must make a second hurdle and then make that call.
I see. How is a capital murder case? Is it any different, really, other than the ultimate result, which could result in the death penalty? Is it any different than any other kind of case, really? Any other kind of felony criminal case, would you say?
It's very different. It's a different creature altogether. Everything in a capital murder case moves. If you could picture this in a regular criminal case, if you were shooting a film, it would just, you couldn't tell the difference from one frame to the other. You just, but in a capital case, it's frame by frame shot. It's a very deliberate process, and well, it should be a deliberate process.
I see.
After all, a person's life is at stake.
I see. But that had only come up once in your court, correct?
That's correct.
I see. And you handle a number of other sorts of felonies, I guess, right? Aggravated assault, aggravated sexual assault, etc., correct?
Yes, sir.
And are any of those particular kind of cases stay in your mind more, or that you think are anything illustrative for the viewers to know about in any way?
Well, what's more troublesome to me, cases that I do not like to see in the shelf, but cases that are presented to the grand jury and on which the grand jury returns an indictment. That's offenses against children. I those cases, of all types of cases, are the ones that are of chief concern to me, and ones that I don't want to see sitting on a shelf, ones that I want addressed by the court and prosecuted as quickly as possible.
Well, why is that? Why is it more important that those cases be prosecuted quickly and/or versus maybe a series of continuances? Why is that? Why do you think?
I think if you break into a car and take a CD from the dashboard of the car, it's very different from offending, injuring, assaulting a child.
I see. And so I guess on those particular sorts of cases, let's say there's aggravated sexual assault of a child,
Yes,
correct?
sir.
When we say like someone is charged, for example, if I would say he's charged with aggravated sexual assault of a child, what does that usually entail? Aggravated. Does that mean a deadly weapon is used? Does that mean the child was hurt badly? What does that mean?
It means that the child was physically injured, assaulted.
I see. We had some years ago, there was an issue regarding some of the sex offenders that were placed on probation, putting signs in their yards regarding that being a sexual offender to notify the people in the community that they were a sex offender. And then I think it went up to the Texas Supreme Court, and then Judge Vinales had ruled on that, I believe, and then the Texas Supreme Court upheld that. As a condition of probation, if you give a sex offender probation in certain circumstances, have you ever made that a requirement that they have these signs in their yard?
No, Mark, you know, a judge who makes such an order has his own concept of how that's beneficial or constructive to either the defendant or the victim or society in general. That's not my view. But I don't criticize that judge either.
I see. So you haven't really necessarily made that a condition of, but let's say a sex offender, a condition of probation for a sex offender. What are some of the conditions of probation a sex offender might have to go through? When I'm representing someone who is possibly getting probation as a sex offender, I tell them, look, this is not like getting probation for anyone else. This will be with you the rest of your life. You'll be on a sex offender database. You have to notify them when you move. And this is nothing light to take. You may want to take this case to trial because of the gravity of being labeled a sex offender the rest of your life and the very onerous burdens of being on probation. Is that correct?
That's correct. Certainly the spotlight is on that person, and the Nueces County District Attorney's Office is prosecuting those persons who, one of the requirements that you mentioned was a registration requirement. If you fail to register, the Nueces County District Attorney, and again, rightfully so, is prosecuting those cases. And so here you are on probation on a felony case. You fail to abide by the registration requirements, you're going to pick up another felony case.
And if you move too, right? The registration is part is if you move,
yes, sir,
and you fail to register, because I have represented the guys on that before. They said, well, I moved, and you know the allegation was they moved, and they pick up another felony as a result.
Yes, sir.
You know, I was in court not too long ago in an unknown county, in an unspecified county, and there was some allegation that an attorney was intoxicated when making a plea on behalf of his client. Have you ever seen an instance like that?
I have, Mark. I've had an instance where an attorney, I've had a couple of instances where an attorney was impaired. You could, in the course of appearances, detect that something was wrong. What the problem was not clear to me. But obviously there's something distracting the attorney. That's clear. On a second...
Other than a personal problem.
Well, you know, you never. That's why you can't jump to a conclusion
Sure.
right away. But it was obvious that there's some distraction, that there's some impairment, and when the case, after 2 or 3 appearances in court, actually came to trial, I abated the proceedings, met with the attorney in chambers, and asked, and it's very delicate, asked if there is a problem, and fortunately that attorney was forthcoming and acknowledged that there was a problem. It was an addiction to one of the substances that's a controlled substance, and he availed himself of help. Some years later, I got I'm happy to say this, that some years later I got a letter from that attorney, and he had argued a case before the Fifth Circuit and expressed great appreciation for the intervention rather, and but the tough and hard part was up to him. He addressed it. He obviously got it under control, and so I was happy to see that result. This other matter that you allude to, you were sitting in court. Is that correct?
Yes.
Yeah. And I detected again that there is something distracting that individual. What it is, I don't know. You don't know if somebody has not slept well, is catching a cold,
certainly.
recovering from a cold.
And I've told clients before, this is a performance-oriented job, and sometimes lawyers could have an off day.
That's correct.
They have sick, they have personal problems,
Yes,
etc.
Yes, sir.
And it'd be very unfortunate if that happens during a trial, but it does happen. I'm sorry.
But it was brought to my attention that there was a very, very strong odor of alcohol about that person. And of course, Mark, that if that person is representing a client, the exposure to this particular person was 10 years in prison. And that's, you want a person that's able, fully capable of representing you in your best interest when you have something like that at stake. And if that person's not operating at full capacity, you just cannot allow that to go forward. And so again, in 15 years, this is only the second instance. I'm not saying that this is the instance where a person may have been under the influence of something, but where the person was obviously impaired, more obviously impaired, I should say, and again, this person was willing to avail himself of help, and so.
I see. Well, what would happen, let's say that that wouldn't have been caught during the proceeding, and that the lawyer went through the proceedings intoxicated, and that I guess if later then, I guess there would be some sort of claim if the man received some term of prison, man or woman received some term of prison time, he could later probably allege, well, look, my lawyer was intoxicated, ineffective assistance of counsel. I would assume something like that could occur, correct?
Sure, sure. I think there was an instance on, I don't know if it was in the national news, but it certainly made its way to YouTube, where there was an attorney that was impaired, clearly, obviously impaired, and appeared in court under the influence of alcohol. This was not here in our jurisdiction, it was in some other state. But so we know that that happens, and certainly that's...
Yes, apparently it happens in all the professions, because you'll hear about, you know, pilots, you'll hear about doctors occasionally, etc. So I guess all the people in these professions are human, and they have, you know, all the same foibles that we all have.
I think it would be a very difficult thing. You yourself have mentioned that you've smelled alcohol on the person.
I mentioned beforehand, through the years, through whatever the 24 years I've been practicing, I think I have smelled alcohol on the breath of, I don't know, anywhere between 4 to 7 attorneys in court.
Yeah. And I don't think we should ignore that, Mark. Us individually, if a doctor is performing his duties with patients and he has alcohol in his breath, or other professionals. I don't think it's a thing we ought to ignore.
So if I smell alcohol on the breath of a lawyer in court, do you think that I should report it?
I don't know that.
Or should I address it to them? How do you think it should be handled?
As you deem appropriate under the circumstances in that particular instance, but I don't. What I'm saying is, I don't think it's something we should ignore. I don't think you're doing any. First of all, it's a tremendous exercise in misjudgment to appear in court with any influence of alcohol or other substance. Even physically, when you're not well, you need to address that, and you're not doing anybody any good by ignoring that. And it's,
well, you know, yeah, I think you're correct. Of course, you know, if you don't know the attorney real well, it's hard to address them personally. But regarding the physical problems, though, you know, a lot of times judges, you could be having physical problems, but unless you know, some of us don't go to doctors as much as we should. And I don't know that if we just went in and said, I don't feel well today, I don't know that the average judge would take great sympathy for us in terms of a continuance or something, unless we had some sort of medical excuse. What would you say about that? I never recall hardly, maybe I've done it once or twice, but usually, you know, I'll go even if I don't feel well unless I have a medical excuse. Do you have any sort of procedure in your court for that?
No, Mark, if you told me you weren't feeling well, or anybody, that's, you know, I just can't imagine a judge that would not ask you to go leave the courtroom and take care of that business first.
Sure, and I think this last year with the swine flu scare and all that, there's probably, I think your people are a little bit more sensitive to it.
Yes, sir.
Haven't I seen in some of the docket calls where they bring in the prisoners, I think for a while, weren't people wearing masks from the jail? Did you see that for a while?
Well, no, I didn't, but I think from time to time you see that. And I think it's the medical personnel at the jail that make that call. I certainly ask, why is that person wearing? Should the rest of us take some precaution with respect to that person's condition?
You do a lot of, we've never talked too much on the show about family law cases. You'd mentioned, of course, people who are accused of crimes involving children, and many of the defense attorneys, of course, represent those people. But let's talk a little bit about family law and divorces, best interest of child, CPS, grandparents' rights. Let's talk about grandparents' rights first. Every once in a while, and I don't do family law per se, but I'll have grandparents call me up and say, what right do I have to my children in this divorce proceeding? My daughter or son is getting divorced, and I'd like to see the grandchild. And what rights do the grandparents have? Do they have any?
They have been, over the course of the years, restricted. They've had greater restrictions placed upon them. So, very narrow. But they do have some rights.
They do have some rights, some visitation rights, etc.
Yes, sir.
And the let's say in a divorce proceeding, are there often custody disputes in divorce proceedings regarding who's going to have custody of the child, and what is the terminology for what is the terminology for who has major custody? What is it? Primary?
Primary custody, yes, sir.
Primary custody, and the other one is, what is it? What is the other one? Secondary custody or something?
They're the primary conservator, the possessory conservator.
Primary and possessory conservator. Let's say if I'm the primary, I get divorced and I'm the primary conservator, what kind of rights does that give me with the children?
The primary distinction between the primary conservator and the other parent is the right to determine the residence of the child, the domicile of the child.
I see. And so if I'm the primary conservator ordinarily, then the child's going to be living with me, and the secondary conservator gets some sort of rights. Isn't it like statutory every other weekend, et cetera, and maybe so many months during the summer? Is that
Yes,
how that
sir.
works?
Yes, sir.
Then let's say that we have, regarding some of the child the child issues, we have CPS comes in and sees something, the child's being neglected or abused. Do you see many suits involving termination rights of the parents?
Those are handled in County Court at Law 5. Judge Terry Shamsey handles those cases, those CPS cases, Child Protective Services cases.
So you don't handle those at all?
No, sir.
And the, how about the, let's say that I would go into your court and let's say that I want to do it, let's say adoptions. Do you do adoptions in your
Yes, sir.
court?
That's one of the
that
great
makes you smile?
pleasures. Yes, it does. That's
All
one
these
of the
other things are not very, this is a very, happy,
Yes.
divorces or child abuse or lawyers in the courtroom, but the adoptions, you handle adoptions.
Yes, sir.
Let's say that, let's say that a child wants to, let's say parents, do they come to you that they want to adopt a specific child? Does the child have to meet, does there have to be certain requirements? How does this initiated? How is this
Well,
done?
the person that wants to adopt a child files a petition for adoption. There are 2 independent studies that are prepared for the judge, for the court, so that the court has some independent view as opposed to what the petitioner's attorney presents and represents to the court. And one of those independent studies is a home study. The home, the prospective adoptive parents, their backgrounds, and so on. And the other study is the background of the child and so on. And that person may be called to testify, those that prepare those studies.
Who is the person who prepares the home study?
Well, various courts utilize the services of persons that express an interest in preparing such studies.
What is this CASA I always hear about? CASA, is it called?
The court-appointed special
Do
advocate.
they do those?
I don't know. CASA is another branch that,
Okay.
again, primarily works for or with, in cooperation or in conjunction with the County Court at Law 5.
So of course, has there ever been an occasion wherein somebody wanted to adopt a child and there's been a recommendation against it? I would assume that has happened in your court before.
I've never seen it.
No, you've never seen
No.
it? So ordinarily then, is it a complex proceeding to adopt a child?
It is. There are all of those components that have to be prepared, ready for the court at the time of the actual adoption hearing.
Do you, I have had men call me before and say that a woman is alleging that this baby is his. Do you make that determination in your court? Parentage determinations, do you do that?
Yes, and again, there is an independent study that's presented to the court, and that's genetic testing.
Has genetic testing, since you've been, I guess probably, I think we started practicing about the same time. I think they've been doing have they been doing genetic testing all that time?
Yes, sir.
Okay. So, it's not like you can come in and say, is there ever any ambiguity in the testing regarding whether or not this is your child? Or is it pretty definitive now?
It's what I've seen is it has been definitive.
Okay. So if, basically, if that child is yours, and that woman says it's yours, and she wants child support, and she proves that child's yours, you're going to be paying child support,
That's
correct?
That's correct. Yes, sir.
And that child support is based upon what? Percentage of your gross income? Let's say that that's one child and you don't have any other children. It's based on what? Your percentage of your gross income?
Yes, sir. That's set forth by the Texas Family Code.
What is it, 20% or 25%?
Yes, sir.
20%?
Yes, sir.
So you're going to pay 20% till that child, what, reaches what age?
And there are a number of factors. It's not as simplistic as
Okay.
that. If they have other children, they're entitled to a certain percent offset, and so on and so on.
Okay.
But the guidelines are there in the Family Code.
Now let's say that, and this is the family code that I brought up here because I thought we'd talk about it somewhat, even though it's kind of not in my, it's 4 volumes there. Let's say that let's say that the man, let's say that the woman, for example, just for some fact-specific situation. Well, let's say a woman says, "I don't want my child anymore. I want to put it up for adoption." There's something called she could voluntarily relinquish her parental rights, correct?
Yes, sir.
Is that a very complex proceeding that you found?
I've never seen something like that.
Have you seen the man do it or the woman do it?
Usually those are driven by an agency like Child Protective Services worker. It's not self-generated. I want to give up my children. I'm going to terminate my parental rights. No. That's usually when there's problems in the home. That's a proceeding generated by an agency like the Child Protective Services Unit, which seeks termination of parental rights in such situations. And again, those are cases that are handled in County Court at Law 5.
So okay. You also handle, let's talk again about the criminal cases. You know, our courtrooms in Nueces County aren't real big, are they?
No, they're small courtrooms.
Smaller than any I think I've ever seen.
And all of the courtrooms have undergone some remodeling, and sad to say, happy, but sad to say that they're you just can't expand. There's no room for expansion of the courtrooms. The size of the courtrooms is limited by the structure.
I have never seen.
But with this last remodeling, we've even suffered loss of some seating, seating capacity, and it's for a very good reason, and that's to accommodate wheelchairs. So I think we've lost 2 or 3 chairs in the courtroom seating area.
But in the counties I've practiced in, San Patricio and Claiborne County and Aransas County, etc., and Jim Wells, it's the smallest district courtrooms I've ever seen. And a lot of times there's physical problems in terms of getting in the number of jurors on a major case, isn't there, to question the jurors?
Oh, any significant major case cannot be, you can't handle those in the courtroom. We've outgrown that. And unfortunately, we've seen a number of major cases, cases the trial of which is going to be more complex. We can't handle those in the courtroom. At least not the veneer panel, the greater panel from which you select the 12 jurors. Once those are selected, once the 12-person jury is seated with 1 or 2 alternates, you can then go back into the courtroom, into the regular courtroom on the 7th, 8th, and 9th floor and proceed with trial in those cases. But when you have 4 or 5 attorneys on one side, 2 or 3 on the other side, and when you have a complex, when you need a greater jury pool, you can't handle those in any of the courtrooms in the 7th, 8th, and 9th floors of the courthouse. Can't.
And that's what I had found when I had been trying. As a matter of fact, it was an aggravated sexual assault of a child case, and there were a number of witnesses. We had to go, I guess it was, I don't remember which floor it was.
5th
probably
floor.
the 4th floor, and pick from an amazing number of people in this huge room to try to ask all these various possible jurors if they knew any of a number of witnesses, etc. And then, of course, they have to be moved then. So I guess that's some coordination issues then, right? It's a lot more coordination issues than in other courts.
You have to make those preparations in anticipation. I'm about to launch trial in a major criminal case. You have to have, and as with that capital murder case, you meet with the representatives from the sheriff's office regarding all the security issues, the movement in and out of the courtroom of the prisoner or prisoners. You meet with the court administrator, the court administrator's office for all of the logistics regarding the veneer panel, the panel of citizens that are coming in for jury selection. And then, of course, you have your own court staff that meets with all of these people, the sheriff, the court administrator's office, your own courtroom staff, your bailiff, your court manager, regarding, again, all of the logistical issues in handling the start, the breaks, and the matters at the conclusion of the day's work, and so on. It's a pretty complex undertaking.
Yes, it is. And and as you're stating about logistics, you know, there's the way our courthouse is set up with it. You know, you don't even have a lot of physical room back in your chambers, do you? Because there's no room for witnesses back there or anything.
Well, you know, all of this business has become so much more complex, and if I understand in Travis, Austin County, they have a criminal courts building, an entire building dedicated to the criminal courts that is new. At least when I say new, I mean 5, 6, 7 years. And I understand that Travis County is ready to start construction of another courts building. I don't know how old our courtroom is, somewhere between 25 and 30 years of age, and we have so many needs that we're not able to accommodate because of the infrastructure.
Certainly.
For starters, technology, the new equipment that attorneys need to use in the courtrooms, the seating and
Sure.
the areas for witnesses. Sure. We have none. Areas where attorneys can meet and consult.
I had a specific case wherein all the witnesses for the prosecution were together, and then the court manager had heard the two witnesses discussing the case improperly, and of course if they would have been separated, that would have never happened. A mistrial was not declared, but it could have. They weren't supposed to be talking to each other and discussing the case. Sure. And I guess with better facilities that wouldn't have occurred. Well,
I don't know that you're ever going to have a facility where you separate and put in individual cells the witnesses. And I mean that as a reference to a structure. Yes. But it's also the responsibility of the attorneys to see to it that the court charges and instructs the witnesses with sure. Gives them those instructions regarding discussion of the case as it gets ready to start and during the course of the trial of a case.
Yes, there's a special courtroom that's been constructed over the last 5 to 7 years for more major cases in Nueces County, correct?
That courtroom is on the 5th floor, but even that courtroom, I have had several cases where even that courtroom is not sufficiently large enough to accommodate the need of pretty complex cases. I've had to do jury selection and work in the central jury room. That's that courtroom that seats about 600 persons.
Well, I don't know. Is there any discussions of any of these issues or anything on the books regarding addressing some of the issues regarding some of these logistics of the sizes of the courtrooms, etc.?
It's not even a matter of discussion. It's not on an agenda. I have not seen it as part of any master plan by the Commissioner's Court. But I'll tell you, sooner or later,
it's going to have to come up.
Yes, like Nueces County already. When you consider the work that the district courts are handling, already qualifies, is ready for the addition of 1 to 2 additional district courts. But even if even if the Commissioner's Court were to approve such, I don't know where you would put any more district courts in the courthouse structure.
Well, it's an interesting issue. I have seen attorneys come in from other counties and say that they're amazed that you have an afternoon docket, a morning docket, and an afternoon docket. That I think that was Harris County attorney mentioned to me that they only have cases called in the morning, and then after that was all. And then they would mention to me that they're amazed that our judges have afternoon dockets as well. And I had an occasion of trying a case in Bexar County recently, wherein we tried the case over the course of 3 days, and it was a large courtroom, adequate facilities, and the judge wasn't hearing other matters in between the trial. In other words, hearing pleas, hearing sentences, etc. So I would have to say that it would appear to me, based upon personal experiences, the judges in Nueces County are hearing a lot of cases, a lot more than other counties that I've experienced. So is that what you're saying about the addition of the courtrooms?
Oh, I don't know whether they do more work than we do, or we do more work than they do.
I'm just saying, but, anecdotally, it seems that way to me. I don't know in some of the courts that I've been in. That's all I know.
Let me tell you what you see, Mark. In other counties, like Travis County, like Harris County, like Dallas County, you have centralized dockets so that the court administrator's office says, Judge DeCarlo, here's your work for the day. That's it. And this case X, you may hear it today. If case X needs some other work done in 2 weeks, case X may be heard by Judge Jones.
Right.
In Nueces County, you don't have the centralized docketing system. When a case is filed, it lands in a court and it remains in that court for the rest of its life, so that I'm responsible for an inventory of cases in the 148th District Court, as are the other courts. In cases, in jurisdictions with a centralized docket, you're not responsible for any one case. You're responsible for a day's work.
So, and I have wondered about that. I know a lot of, in other words, you have a case, say in, again, Bexar County or Harris County, a pretrial matter could be assigned to any court on that case.
That's right.
Do you know who's going to be trying the case ultimately? Do you know?
No.
You don't know. It's all.
It's a work that's handed to a judge for that day. That judge has no responsibility for, it's not singly responsible for that case. In Nueces County, I'm responsible for the case that you file from its inception to the duration of its life.
So there can't really be in the bigger counties then, oftentimes, you can't really forum shop for a certain, because some years ago there was some sort of scandal wherein attorneys were filing cases and then non-suiting them and then trying to get a judge that they thought was more favorable. In the bigger counties, that can't happen because you don't know who's going to get to court. You don't know who's going to try the case anyway.
That's correct. Nor can it happen in counties like Nueces County. A case is randomly assigned by the computer system, by their computerized system, and it remains in that court. And any matter relative to that case cannot be heard by any other court unless that judge gives you permission to have some other court address some matter that needs to be addressed.
But nonetheless, once it's randomly assigned to that judge, it's randomly assigned permanently.
That's correct.
But in these larger counties, it's not really assigned to any judge.
It's not.
At any point.
That's correct.
But I can't...
There's advantages and disadvantages to that system.
Certainly are, because in other words, you could be having every time in, like, say, Bexar County, then in Harris County, the judge has no knowledge of the case whatsoever, even on a previous hearing.
That's one of the primary differences. Absolutely.
And of course, with that, then I guess there's no prejudice one way or another, but then they don't have the knowledge of the case. Right. But I don't quite understand how that could. I guess I'm having a hard time understanding how that works exactly, because your court is the one. What's your court number? I'm sorry.
148.
148. And you're the judge for the 148. But if you get a case, so if a case is in whatever Bexar County or Harris County, and it's assigned to whatever the number would be, 257th, whatever the number would be, the judge would be the same in that court, though, right? There's not more than one judge in the court, or they would.
It's not assigned to that court.
Oh, it's not assigned to the court.
The day's work is assigned to that court.
I see.
The day's work, and that day's work, and the assignment, the allocation of the time, how much that day's work needs is determined by the court administrator's office. The judge has no say in what the judge is going to hear for that day.
I see. In commensurate with a criminal trial, let's say that this is something that I haven't seen done in a long time. But let's say that the state puts on a case in a criminal trial, and the evidence isn't adequate to support a verdict, and the criminal lawyer, sometimes we do it, sometimes we forget to do it, even if we're sober. And I made a joke about that earlier, that the practice of the law is so difficult that you could be whatever, in shape and healthy and alert, whatever, and still, you know,
it demands its very best.
It's very demanding. Yeah. So anybody that goes into court under any substance is obviously being very unprofessional, et cetera. So I don't mean to make light of that. But let's say that you ask for an instructed or directed verdict. Have you ever given that in a criminal case?
Sure.
You have?
Sure.
And in what facts, circumstances might you do that? That was just simply we're in
the evidence doesn't rise to that level where it supports the elements of the offense, which the state must prove in order to carry its burden.
And that burden in a criminal case, of course, is beyond a reasonable doubt.
Yes, sir. Or some element that's required under the law as to that particular offense.
Yes. Let's talk about beyond a reasonable doubt. For some years, this standard was there, beyond a reasonable doubt. And then I think the Supreme Court said, well, we're going to allow to charge in the instructions at the end of the case, beyond all doubt, that the state prosecutor doesn't have to prove his case beyond all doubt. Then they said then they went back on that, I think, and they said, well, no, that's not necessary to be included. Where is the standard now on this? Do you, at the end of at the conclusion of your cases, when the jury is charged, do you now put in the jury charge the state is not required to prove beyond all doubt if they ask for it, or you don't include that at this time?
No, it's part of the standard. It's still part of the standard inclusion. No definition of reasonable doubt.
I object to that. That's why I'm so endeared by the judges. I'm just joking.
No definition of what the term reasonable doubt means, but certainly the burden as to reasonable doubt. The state's not required to prove its case beyond all doubt. Mm-hmm. It's required to carry a burden and prove its case beyond reasonable doubt.
Yeah, like I said, I always object when I see that the state isn't required to prove beyond all doubt, because it's not a preponderance of the evidence either. It's beyond a reasonable doubt. It's kind of an ambiguous term, isn't it?
Yes, sir.
And it's up to the jury to decide. If the jury can't decide a case, what happens? Does a jury in a criminal case, does it have to be unanimous?
It has to be unanimous, and the situation you referred to just a while ago is loosely referred to as a hung jury, and the jury sends you the message that that it's unable to come to a consensus, to a unanimous verdict, decision on the case. And they'll send you a note, tell you they're struggling with that. And they'll send you another note and tell you they're struggling with that as the hours pass. And the court tells them to continue their deliberations after receipt of such a note. And
at what point do you make a decision that the jury is not going to be able to come to a conclusion in a criminal case?
There's no hard and fast rule.
Hours?
There's no hard and fast rule. When a jury just categorically tells you, we've gone as much, we've done as much, we cannot, and we do not expect any change.
What's the longest deliberation you've ever had in a criminal trial that you remember?
Well, long is relative, because there are some cases that the evidence is fairly straightforward, and the length of time that the jury expands in addressing the evidence in the jury room, deliberating over the evidence, may be somewhat inordinate. I mean, to a fairly direct, not complex case.
Certainly.
And
So
then
it
you
could be
have
simple.
another one where it is very reasonable for the jury to spend the amount of time that they spend on a case.
I guess I was actually not I was just asking, was it 6 hours, 8 hours?
I've had
12,
juries
2
that have
days?
deliberated 4 or 5 days.
Is that right?
Yes.
And in the event that they can't come to a conclusion, then what happens?
Then you declare the mistrial. And that case does not go away. It's got to be put back on the chute, and you start all over again with it.
Usually in a jury, it's usually required, well, it is required that a foreman be chosen, right?
Yes. That's done by their own peers behind closed doors.
And what is a jury foreman supposed to do?
He is the one that presides. He's the umpire, the referee, and I don't know the dynamics that have you ever served on a jury?
I've only been made it up to the picking of up to voir dire. I've never made it into the jury. Have you?
No.
No.
I wanted to. I don't know the dynamics.
I don't know either.
But I'll tell you what, a court appreciates having as the umpire, the referee, the presiding juror, a person who has a strength of character to guide the 11 other peers, and to demand the work that needs to be done of that body. If you have somebody that doesn't have that strength of character, you may have that kind of result where a jury is not able to reach a verdict.
And how about in your civil cases? Do you often have a case where a civil case can't come to a verdict?
I've never had one in 15 years. Never have.
That's very interesting.
I've had only if I've had a handful of cases in 15 years, that's too many. They're not that common.
And you mean for the criminal? You've had maybe a handful of criminal cases?
Maybe a handful of
mistrials.
cases. Yes, sir.
And also in a criminal case, of course, you've probably had a number, though, wherein there was a lesser included, wherein the person accused of the crime wasn't convicted of the higher crime, but maybe a lesser included offense. Is that right?
Well, that's not a loosey-goosey situation either. You know, so much work is fought outside the presence of the jury with rulings and what goes to the jury and what doesn't go to the jury. If in those deliberations and arguments outside the presence of the jury, not in the course of the trial work that takes place in the courtroom, but in sessions where the attorneys argue the law to the court, they might get a lesser included offense included with the charge, so that the jury might have that option, might not.
And as an example of that, of course, would be maybe in a murder case there might be a lesser included offense of what?
Aggravated assault, for example.
Aggravated assault, for example. But you have had jurors come in with, I would assume.
Manslaughter and so on.
Yes. You have had that occur.
Negligent homicide and so on.
You have had that occur
Sure.
before, correct?
Sure.
And yes.
I've got that other matter and.
Well, I wanted to thank you. This is
absolutely.
Judge Marisela Saldena has been our guest. She has another matter she has to run to, and she has an election coming up. I wanted to thank you for coming on.
Absolutely.
Judge Saldena, that's for which court again?
Absolutely.
148?
The 148th District
148.
Court.
Thank you, ladies and gentlemen. Good night.
Thank you.
If there's been trouble, I will plead not guilty. It must be someone else. You know it can't be me. I filed my income tax return, thought I'd save some dough. I cheated just a little bit. I knew they'd never know. I got some money back this year, like I always do. They'll have to catch me before I pay Internal Revenue. Good morning, Judge. Why do you look so mean, sir? And Mr. Judge, what can the charges be? If there's been trouble, I will plead not guilty. It must be someone else. You know it can't be me. My wife and I, we separate. I took a ride with little old Lucy Brown. We went to all the honky-tonks. We really got around. She's 5'2" with eyes of blue and pretty as a queen. I didn't know her pop was a city cop and she was just 15. Good morning, Judge. Why do you look so mean, sir? And Mr. Judge, what can the charges be? If there's been trouble, I will plead not guilty. It must be someone else. You know it can't be me. I filed my income tax return, thought I'd save some dough. I cheated just a little bit. I knew they'd never know. I got some money back this year, like I always do. They'll have to catch me before I pay internal revenue. Good morning, Judge. Why do you look so mean, sir? And Mr. Judge, what can the charges be? If there's been trouble, I will plead not guilty. It must be someone else. You know it can't be me. My wife and I, we separated just the other day. Last thing that she said to me was, brother, you will pay. She said I'd pay her every week. I'd better never fail. I said before I send you a dime, I'll die right here in jail. Good morning, Judge. Why do you look so mean, sir? And Mr. Judge, what can the charges be? If there's been trouble, I will plead not guilty. It must be someone else. You know it can't be me. Be mine, my love, 'cause I'm so sweet on you. Be mine, my love, 'cause I'm so sweet on you. Well, I'm waiting and I'm hoping that you love me too. I need you, baby, say you need me too. Yes, I need you, baby, say you need me too. Say you love me, make all my dreams come true. Fortune teller, read my hand, make my baby love me much as she can. Be mine, my love, I'm so sweet on you. Well, be mine, my love, I want to do oh so much for you. ocean blue. Yes, I tell you, baby, I'd swim the ocean blue. Well, ain't no use to me lying, I just couldn't stay away from you. Be mine, my love, I'll give you all I own. Yes, be mine, my love, I'll give you all I own. Be mine and I'll work my fingers right down to the bone. Be mine, my love, forget all about the past. Yes, be mine, my love, forget all about the past. Think about your future and how long our love would last.
Hey, boys, did you hear that noise? Did you hear that thunder sound? Say, boys, do you know that noise?
Well, Mr. Blues is coming to town. Get your business straight. Mr. Blues is coming to town. Get your business straight. Mr. Blues is coming to town. You've got to stop that jive that you've been putting down. I might come by plane, might come by train, might grab a boat and sail. So don't be surprised if you open your eyes and find me in your morning's mail. Catch your business straight, Mr. Blues is coming to town. Honk my horn like I did before. If I catch a cat sneaking out the back, I'm gonna run over him with my Cadillac. Get your business straight, Mr. Blues is coming to town. The telephone. I'm gonna lock all the doors, snatch out the telephone. So Mr. Blues and his baby can have the house all alone. Well, Mr. Blues is coming. Yes, I'm coming to town. Mr. Blues is coming. Yes.